Welcome to the Betweenity webinar on the new ECOWAS merger regime. It is great to have you with us. We have guests from across the world, from the United States and the whole of Europe and the UK and all across Africa and up to India. So you are so welcome, and it is great to have you here with us. Also, great welcome to many of the new ERCA Council members that have joined us. I'm aware that Dr. Juliette, who's the chairperson, that she will be joining us. Welcome, Dr. Juliette. Also, Antoine, Sami, Humberto, Adama, Banding, Joao, Leonard, Dr. Moore, and Biva. Many congratulations with your appointment recently as part of the Council of the ERCA, and we wish you all the very best with all the major foundational work that would have to be put in place at the ERCA. And then a special welcome to Dr. Simeon Kofi. Dr. Simeon has been the Executive Director of the ECOWAS Regulatory Competition Authority for a couple of years now. And he's a very busy gentleman, and we are really very grateful, Dr. Kofi, to have you with us today. There's a lot of excitement about this webinar. People are very eager to listen to you and to ask their questions. So thank you so much for being here with us today. We really look forward to engaging with you. Just a couple of arrangements. Please put all your questions in the Q&A and not in the chat. We will not be monitoring the chat. All questions will be answered after the presentation, and just note that the session is being recorded. Just a couple of quick questions on Betweenity to those of you who are not yet familiar with us. Betweenity was founded in 2020. We are an independent Africa competition law and policy news service, widely respected, and we render services to a wide range of constituencies, which include global competition law practices, multinationals, economists, advocates, civil society, and regulators, all of them in the competition law and policy space. Betweenity monitors competition law and policy developments across all 64 national and regional competition jurisdictions in 11 languages on a daily basis. And all of the content is posted in English, and we have an extensive database. Now, just to quickly give you a sneak preview, at Betweenity, you will see that during the past 2 weeks, we have posted competition law and policy updates in relation to 22 different African jurisdictions. For example, there you can see Djibouti, Africa as a whole, South Africa, Malawi, ECOWAS, Gabon, Angola is there. There's Morocco, couple on Namibia, there's Wahemu, there's Botswana and Kumesa and Zimbabwe, and there's Tunisia. There's Guinea and Kenya. So there's Egypt and Libya and Tanzania and Liberia. So as you can see, we cover the whole area of Africa. And to quickly just give you an indication of the search page contains various selection options on the left-hand side. You can see you can enter a custom word, select a date range, select the type of content that you'd like to monitor, but then you can also slice and dice per topic, just below that per African country, also per economic bloc, and also per industry. We have about 45 different industries that we monitor. For example, if you're going to click on ECOWAS, you will immediately get the latest news on ECOWAS. And here, for example, you can see that we have already started through deep scanning to check what are the major areas from a sector perspective that may be prioritized by the ERCA or by the ECOWAS Commission as a whole. And here, for example, if you look at this article, you will see that we also have identified future ways of enforcement that are being experimented with. So for those of you who might be interested in a demo on Betweenity, you can just quickly click yes, and then we will reach out to you afterwards. Right. To continue our presentation today on the ECOWAS Competition Regulatory Authority. ECOWAS consists of 15 member states, as you would know, but in January of this year, 3 of those member states, Mali, Burkina, and Niger, decided to withdraw from ECOWAS, and that was due to particular sanctions that were imposed as part of coup-related violence that took place during the last couple of years. Although the merger regime has just started, the ECA has been active for many years already. And its activities have included a digital market study, and this is something that is currently ongoing in the e-commerce and the online platforms market. If I understand correctly, the draft report has already been reviewed and validated by the different members. But also market studies in transport, agri, and pharmaceuticals. These are generally some of the high priority industries in Africa. The ECA is also engaged in various capacity building exercises with other ECOWAS member states, as well as WAMU, and it has entered into various memoranda of understanding. Now, the merger regime is a very welcome development, and that is for a couple of reasons, but not least the fact that ECA operates in a very, very demanding part of Africa. The geopolitical conflict that I referred to, it's a critical issue in West Africa, and persistent inflationary pressures. We tracked that quite specifically during the past 4 years due to the combined effect of COVID and the coups, and of course other droughts and supply chain difficulties. And that area is specifically exposed to inflationary pressure. But also from a macroeconomic perspective, there are high and rising public debt, as well as tight monetary policies that make it very difficult for a regulator to move really freely. And this is why it is important for us to sympathize to some extent with the ECA, because it has the wonderful combo as a result of all of these above factors of not having to deal with very high expectations, but also very little resources. This is one of the reasons why we decided let's have a webinar on the ECA merger regime, so that as many people as possible can be informed about the rules, not only those that are written, but those that are probably going to be just spoken about in the near future, but that as many of us can have an idea what exactly are the expectations of the ECA. We sent through a couple of questions that Dr. Coffey will handle for us. We also anticipated some of your questions and we sneaked them in as well. They're a little bit offbeat, but please go ahead and type your questions in the Q&A if you feel that your particular question has not been answered. I also received a couple of questions from clients and I will also handle them as part of the Q&A. So Dr. Simeon, all over to you. Thank you for being here with us today, and we are looking forward to listen to you.
Thank you very much, Odi. It's a great pleasure to be part of this webinar today. And before starting, I want to say thank you to the organizers to for this opportunity given to the ECOWAS Regional Competition Authority to present what we are doing. And also I want to send my regard to all the distinguished participants to this presentation, to this webinar. And I want to also thank my board members, the chairperson, to be also connected and be part of this presentation. I can start from your introduction, which is well done on ECOWAS and also on ECA. Thank you for that. And the ECOWAS Regional Competition Authority is actually, let me give you the institutional anchoring of ECA. It's actually a specialized agency of the ECOWAS Commission, which is based in Abuja, Federal Republic of Nigeria. And as a specialized agency, ECA has to implement some of the main objectives for the integration process of ECOWAS. And ECA office headquarters is in Banjul, the Republic of the Gambia. And one thing important that I want to highlight in my presentation is the clear mandate given to ECA by the authority of head of state of government to reverse a situation that the tent should not last any longer. Actually, when we take the ECOWAS region, and I'm going to focus my presentation, as you said, on the major regime that is recently finalized and adopted. The ECOWAS major control regime comes to fill an unjustified vacuum that should not continue. There is a clear gap, and it's not at the regional level alone, but also at the national level. Maybe with the exception of Nigeria, which is also quite recent, and some extent of Cabo Verde, since last year, if I'm not mistaken, no other ECOWAS country has a major control regime. This is why you are working collectively in collaboration with our partners from member states to remedy this situation. And this situation is not consistent with ECOWAS trade liberalization scheme and the move toward the creation of a common and integrated market in West Africa. Why am I saying that? While thousands of companies and several thousands of products are approved within the framework of our ECOWAS trade liberalization scheme, with new requests every day. Every day, people are knocking at the door of ECOWAS to get approval to be able to trade with the partners of the region. So while these companies are coming to participate in the community market, it is unacceptable that there is no clear, proper regulation on competition between market players. It's why we have been tasked to take necessary measures to be sure that in the next month, next weeks, the ECOWAS major control regime is fully implemented. Let me also talk about ECA bodies. ECA is made up of two bodies. We have the ECA Council composed of 10 members, including a president, a chairperson, and it's why you can see that you don't refer to them as commissioners, as you can see in many other jurisdictions, because the word commissioners is referred to the commissioners of the ECOWAS Commission. ECOWAS Commission, in addition to the president of the commission and the vice president, you have 5 commissioners. And ECA is under the administrative authority of the Commissioner for Economic Affairs and Agriculture. But this administrative anchoring doesn't our role as competition authorities is also highlighted by our supplementary act, giving a certain autonomy of action to ECA, even though you are under the responsibility of the Commissioner for Economic Affairs and Agriculture. I'm going to talk, in addition to the ECA Council, and one of the peculiarity of our institutional arrangement, the members of the ECA Council are appointed according to the ECOWAS procurement rules, after a call for expression of interest. And in this regard, the status of a member of our board is entity personnel. They are not directly representative of member state. The council is the decision-making body of ECA and decide on the report, conclusion, and recommendation prepared by the executive director. So the second body of ECA is actually the executive directorate, which I have the honor and the privilege to lead as executive director. It's the administrative, technical, investigative, and implementing body of the authority. The executive directorate is composed of 3 directorates and 6 divisions that cover the main areas of intervention of the competition authority for competition, including a full division in charge of mergers and acquisition. In addition to these 2 bodies, we have what we call the Consultative Competition Committee of ECA, composed of 2 representatives per member state in charge of competition and consumer protection matters. So this committee plays a very crucial role in the process of adopting our legislation, conducting investigation, and also they give opinion on the draft decision where necessary. So as I said, the council, ECA Council is our decision-making body, and its decisions are binding and final. And also, the only jurisdiction that can, the appellate court for the decision of the council is the ECOWAS Community Court of Justice, based in Abuja. So regarding the various legal tests that guide our action, the first one is the Supplementary Act that establishes the community competition rules and their modality of implementation. This Supplementary Act was adopted in 2008, but the implementation started quite recently. And the second act is the act that established the authority itself, ECA. And there is another act that amends the previous one on ECA by defining clearly the two organs that I just mentioned. And these acts are integral part, according to our rules in ECOWAS, they are integral part of ECOWAS revised treaty of 1993. So the Supplementary Act on the Community Competition Rules define clearly the scope of intervention of ECA, which covers the cartels, abuse of dominant position, mergers and acquisition, and also the state aid, which is not in many jurisdictions, but is part of the scope of intervention of ECA, or state aid that are incompatible with the common market because they can harm trade between member states are under control. And so after this supplementary act, we have also specific regulation on mergers and acquisition, on our leniency and immunity program, and also regulation that give the investigation and notification procedures and the mission composition of the various bodies that I just mentioned. As I said earlier, ECA started its activities quite recently in June 2019. And during this, the first years of our activities, we were working to strengthen our legal institutional framework because after the funding act, no other regulation were in place to implement the act. So you have to work to develop various regulation guidelines and also to appoint the work for the appointment of the members of our board. So it has been a very important task and achievement. And recently, on October 2nd, we were able to establish officially our board. Regarding the merger regime, is actually the main purpose of this webinar. The key instrument that guides our action on the merger regime, on control of merger, as I said, is Article 7 of the Supplementary Act, SA2, and also the Regulation 23 on merger and acquisition, and the enabling rules that provide all the guidelines on mergers, the notification procedures, and the scale of penalties in case of failure and breach of the rules. In ECOWAS merger control regime, our jurisdiction is triggered, and this one, I mean, the notification is triggered when two alternative conditions are met. It's important to note that. The first one is when the combined aggregate turnover of a relevant balance sheet item, whichever is higher, of all merging entities within the common market is more than 20 million unit of account, West African unit of account. The second condition, which is not, I said it's not cumulative, but alternative condition, is when we aggregate common market wide turnover or relevant balance sheet item of at least two of the entities engaged in the merger or acquisition is more than 5 million units of account. Why these two? Let me explain, because the question sometimes come in. Why these two criteria? The criterion B takes into account the fact that the regional market is characterized by a preponderant number of small players, micro, small, and major-sized enterprises. We believe that it is very important to assess the effect of concentration of enterprises that involve players of which more than one is relatively large. In that case, the criterion B can be met without A being met. So if you have, for instance, three entities, A, B, and C, A and B have more than 5 million, and 4 million, this merger has to be notified, even though the combined turnover of the entity is less than 20 million, as stated in the criterion A. So, yes, the notification is also, and you have to have it in mind, in addition to this quantitative criteria on the turnover or any other relevant item of the balance sheet, the companies has to operate in at least two member states. Is where comes the regional dimension that triggers our jurisdiction, because it's our legislation take into account the subsidiarity and complementarity between the various levels, the national level and the regional level. So this is something that also clear. We are not going to fully replace member states in the role of enforcing competition role, but our effort or our action is to complement what member states are doing. Another important point that I have to come in, I think since there are some questions, but I'm just giving the main provision, and the question will maybe come with some details. it's important to notice that many businesses are engaged in the community market. And from some evaluation of our various instruments, not competition instrument per se, as I was saying, you have various instruments. ECOWAS is a custom union. You have a common external tariff. You have also a trade liberalization scheme. The evaluation of these various instruments across the region came up with a clear conclusion that we need to enforce competition rules, especially a merger control regime is critical. And is what you are going to do. And it's why also you are working with various member states that are yet to have such legislation to also put in place merger regime to ensure a smooth implementation of the community provisions. So, Mrs. Odi actually is the main highlight information that I wanted to provide on ECA merger regime. And I'm open for any comment, question, and if there is need for clarification of some of the provision, you are ready to do so.
Right.
And my board members are there. They can also join their voice to mine to also provide some answers. Thank you very much.
Right. Thank you very much, Dr. Simeon. Thank you for sharing that background with us. I'm going to start with the questions in the Q&A, and in between I'm going to add some additional questions that some of the clients forwarded to me personally. The first question is, how do citizens assert their rights within a competition regulation regime? This is probably a fairly broad question, but if this is something that you'd like to respond to.
Please, can you come again?
Yes. The question from Kwaku is, how do citizens assert their rights within a competition regulation regime?
Okay. Yes, I think this is a very important question, and also is actually the purpose of one enforcing competition rule, to be sure that the market is properly regulated, and also to ensure the welfare of the people, of the consumers. So I think one of the most important action of the competition authorities is to ensure that there is a fairness in the market. And this one will lead definitely to ensure at least two things: lower the prices of goods and services on the market, the quality of goods and services, and also ensure that there is no kind of discrimination that will affect negatively the consumers, the people. Mm-hmm. So if I got right your question, I think there is clear evidence that a market well regulated will ensure lead to the benefit of the people.
Right. Thank you very much, Dr. Kofi. A question from Shilufia. How many ECOWAS member states have national authorities, and can ERCA enforce in member states?
Thank you. You know, the situation in ECOWAS countries there are some disparities, and I can mention three situations. The first one is member states that have competition authorities in accordance with what is required in the community rules. Autonomous Competition Commission or Authority. In that case, I can mention FCFC Nigeria, Gambia, Cabo Verde. There are some other countries that, especially the UEMOA countries, that have also competition commission, like Côte d'Ivoire, Burkina Faso, Senegal. But due to the fact that UEMOA Commission has exclusive jurisdiction when it comes to enforcing anti-competitive practices, they don't have the full arm of a competition authority to act. This is a second situation, and there are other countries that have, let's say, a kind of unit or department under the Ministry of in charge of Trade and Industry.
Yeah. And
they are not fully a competition commission. So the situation is varies, and is why one of our mission to be sure that all the countries have a competition, work toward to comply with our rules to set up a autonomous competition commission or authority.
Yes.
So this is the situation in our ECOWAS region.
Yeah, thank you very much, Doctor. I'm going to ask a question that was sent to me. Is there a short form notification procedure for transactions that are not expected to raise concerns?
Excuse me, I have a background noise, please.
Okay, right.
Sometimes it's difficult to hear what you are saying.
No problem.
Yes, please.
We wonder whether there is a short form process for mergers that do not raise any competition concerns. There are authorities that go for that type of short, fast-track type of arrangement where it's clearly not a non-problematic merger. And we wondered whether that would also be the case with ECOWAS.
Okay, you saying that a merger that doesn't have any concern when it comes to competition. So you are asking if such a merger has to be notified?
Notified or maybe just in a short form. So instead of answering 20 questions, you answer 5. And perhaps you
Okay.
also do not attach all the documents, but only some.
No, yes, it's true that you have only one form
Yeah.
when it comes to filing a merger
Yes.
acquisition. You have one unique form. I think
Okay.
it's, and if you also notice that there are some maybe mandatory fields in this form,
Mm.
you don't have actually a simplified form for that.
Mhm.
But if the question that you answer as simple and clear, I think if you think that the information that has to be provided difficult is why you are open for consultation before even in the process of filing your transaction.
Yeah.
You can discuss and see in which extent which type of information
Yeah.
are not necessary, and that one is not completely something that is allowed to have a formal consultation in the process of filing your merger.
Right.
But I don't think it's why making a digital filing procedure is also to simplify.
Yes.
So I
Right.
think for what we have, I don't think the procedure is so heavy,
Mm-hmm.
and the digital form also give you a way to file
Yes, that's
easily.
right. And sir, can one only file digitally, or are the forms also available separately? Must all mergers be filed on the website?
Yes.
Okay.
All
Okay.
mergers that fall within the
The,
condition highlighted in my presentation has to
yeah.
be filed, yes, through
Yes.
this for process.
Right.
Yeah.
Right. Thank you, Doctor. Then a question from the chat. What is the ECOWAS stance towards absolute territorial protection? And would it be the same to COMESA's position? And that also speaks to the whole issue of vertical restraints, which is a big one in Africa, especially in West and Northern Africa. Let me pick up that. So, what would your position be in relation to that, even from a merger perspective?
I think I have to move on from my office, that I I have
So,
some distraction of the
of
road is
noise,
closed. But
I
yeah.
see. Um, should I repeat the question, Dr.
Yes,
Coffey?
please. Yes,
Okay,
please.
yes. What is the ECOWAS stance towards absolute territorial protection? And does it correlate with COMESA's stance?
Okay.
Yeah.
This is an important question. I think also my chair can also come in, but
Doctor, would you like us to involve Dr. Juliet, or are you going to take a shot at the question? I just want to make sure I understand.
Yes, you know, yeah, Dr. Juliet, please, can you come in?
Right, let me just quickly go to Darcy. Dr. Juliet, if you'd like to unmute yourself, you are Darcy.
Oh, can you hear me?
Yes, yes, we can.
Okay, good. Okay, right. Okay. What was the question, Odie?
The question, Dr. Juliet, was what is the ECOWAS stance towards absolute territorial protection? And does it relate to COMESA's stance? And the question is, yeah, okay.
Okay. I think COMESA has been at this for much longer than ERCA has been.
Yeah.
And ERCA's regime is newly evolving. So it's difficult at this stage to rule anything out. As the regime develops, of course, we will come out with guidance towards, yes, I take the point that issues related to vertical restraints are very prevalent on the continent, and it's currently very topical. I know COMESA has put out guidance and regulations on that. We haven't got to that stage yet. So I think at this stage, we are seeing how things evolve. And if we get to the point where we think that we need to go the way COMESA has gone, definitely there will be guidance that will be provided on that topic.
Right.
But at this stage, no, we haven't decided yet as to where we're going on that.
Yes, right. Thank you very much, Dr. Juliet. Thank you for that.
You're welcome, Odi.
Yeah.
Thank you.
I'm just quickly going to mute you again. Juliet. For some reason, I can't find you immediately. I will, Darcy. Right. If I can ask just a quick question again from the list that I received. If the ERCA issues a request for information as part of its assessment, in other words, during the whole merger review assessment, will the clock stop the moment that the parties must respond? Doctor, if you can help us with that one.
Yes, if you request for information and the information may be critical for the review of a transaction, definitely you have to stop the clock.
Right.
Because, and I think it's not in the interest of businesses to delay in providing the information.
Yeah.
Actually, the form that is provided, I thought you for simplified and form that the one is provided give a certain scope of information that can allow us to do a proper review.
Yes.
It's why we invite businesses to provide this information instead of for us to always request for additional information that will delay the process of reviewing the merger.
Right. Thank you, Doctor. Just a quick question. To what does the units of account refer? What is the corresponding currency? Is it US dollar? Or
the unit of account, the West Africa unit of account, is actually, yes, you can. You have an equivalent in US dollar. You have an equivalent in all the ECOWAS local currencies. But actually, the unit of account is equivalent of the IMF DSR.
IMF? Can you just come again, sir? The IMF? Dr. Simeon? Doctor, can you hear us?
IMF for special withdrawal right.
Sorry, sir?
IMF, International Monetary Fund, special withdrawal right.
Special? Right. What is the middle word? So sorry for this.
Okay.
I will follow this up with you afterwards. I'd just like to clarify that. But if we can quickly go to another question. Someone asked for more clarity. Is Burkina, Mali, and Niger? So let me just quickly go back. Is Burkina, Mali, and Niger part of the ERCA? And if not, are there plans for them to return to join the ERCA, or are they gone for good? So, in other words, are they still part of the CCC, if I can say that?
Okay. This question, I think, let me with 3 countries. Yes, these 3 countries, as you said in your presentation, announced that they are leaving ECOWAS. And this decision has not yet been acted because he has to, and there's a process, you are more or less in a certain transition period. So
yeah,
what I can say, they are still members, even though this political situation has seriously affected our collaboration with these countries. But if you have to, let's say, consider and a measure by assessing the effect in concerned countries, and it's appeared that one of them is part of this process, we'll engage with our partners to see how you can get information, and our partners at the regional and also national level, we can assist. But before a final decision on this issue, I cannot say that they are no longer part of the, even though we have some challenges and to have a full participation in our CCC. Yes, for the past few months.
I see. That's very interesting. Okay, right. Can you also explain to us the way forward with WAEMU? In other words, how will that work? Are there any collaborative efforts with WAEMU? And how will that work going forward? Especially in relation to overlapping memberships. We understand that you have entered into a MOU with them, but what can we expect practically in relation to the filing of mergers?
All right, thank you very much. Yes, you have in a situation, I think it's not peculiar to ECOWAS, where you have multi-membership.
Yeah.
And but in our case, all the members of UEMOA are also members of ECOWAS. So our jurisdiction goes beyond, far beyond the one of UMOA. But after discussion, it has not been easy, but you came up with a cooperation agreement to avoid overlapping and also duplication. So the terms of the agreement is quite interesting, and it avoids so many problems, especially a kind of vacuum in the region. This agreement is based on a single control principle between the three levels of competition regime in West Africa. Either the investigation is carried out by ECA, by UMOA, or by the concerned member state. So there's no situation where on the same case, UMOA and ECA will conduct investigation, or even the member state. So this agreement is very important for us, and we really appreciate this collaboration between our two regional bodies.
Yes, yes. When will that be issued? Do you have any idea by when the market will have an understanding of when to file which merger where?
When the market will have can you come again?
Sorry, did you have any idea when that document will be finalized so that the market can know where to file which merger?
Which document? The cooperation agreement with UMOA?
Yeah.
It's finalized. Actually, the cooperation agreement is at the, it has to be signed by the two head of institution. What we call head of institution is the two president of the commission.
Yes.
The president of UMOA commission and the president of ECOWAS commission.
Yes, I see.
So, and I think one party has already signed, submitted to the other party to sign. So
okay,
it will be available very soon.
Right, that's wonderful. That's great to hear. Thanks very much, Doctor. A quick question from this side again. Can merging parties request a comfort letter or negative clearance for mergers on the basis that there are no local effects, even if the thresholds are met? In other words, where you basically say, we agree that the merger is not notifiable, you can go ahead.
Yeah, actually, no. The fact that it's not subject to notification by ECA doesn't mean that it's not going to be by another jurisdiction. Yes. So giving such a letter to say that it's not subject to notification is maybe can to deny other jurisdictional right to also consider this measure. So you because it may not be subject to notification to ECA, but to a member state. So yes.
Right. Right. Thank you for that. We handled this issue. Let me just remove that one. Has the Nigerian Competition Authority indicated that it will recognize the one-stop shop principle where a merger is notified to the ECA? That's quite an important question. based on the history of what we have seen in West Africa, is there buy-in from the member states that they will relinquish control to the ERCA under all circumstances if the regional thresholds are triggered?
Yeah, if the regional threshold is triggered, and also is clearly a measure of a regional dimension, I think it falls within the jurisdiction of ECA, the jurisdiction ECA. As I said, this our agreement is to avoid that the various regimes do the same thing. You have to avoid. So once it's considered by one, the others not going to do it. That one is the rule.
Yeah.
And if it's not, I think it's clear for everybody. If not, you continue engaging on that until it's clear for everybody.
Right.
Otherwise, it's the single control principle.
Yeah.
And that you work toward that for every party to abide for it.
Yes, right. And Dr. Simeon, is the merger control regime suspensory and mandatory? It appears as if it's mandatory if it meets the threshold, but is it suspensory? In other words, if you notified, can you implement in the meantime, or must you wait for the approval?
Yes, it's definitely suspensory.
Right.
Because it's clear, the regulation is clear that a merger has to be notified and it's implemented after the final decision, either approved or with or without condition. So you cannot notify and continue the transaction, no.
Right.
You have to wait until the final decision is taken. So,
yes, right. That helps. That helps a lot. That was a question from many firms. And we have a question from Simon. What is meant in practice by the requirement for merging parties to operate in at least 2 member states? You will recall that one of the thresholds are that even if the acquiring firm does not have a presence in ECOWAS, that the target firm must operate in at least 2 member states. And the question is, what does that operate mean? Does this mean at least 2 parties need to operate in 2 member states? Or is it sufficient that just one party has operations in at least 2 member states?
Thank you for this question. Thank you very much. Actually, what you look at here is the effect of the merger on the community market. The effect of the merger on the community market. When you say 2 ECOWAS member states, companies have to operate in 2 ECOWAS member states. You have to understand operate as activity of production, supply, distribution, and purchase of goods and services in the community market. You may not be physically or one of the party, the acquiring party may not be physically in the country, as long as you have a distribution activity or purchase goods and services in the community market, is shows that this transaction has effect on the community market. So it has to be notified.
Right.
So don't need the two to be in the member state, but the activity can have effect. And this effect, as I said, they have to look at in many ways: production, supply, distribution, and purchase of goods and services.
Yes. Right. Thank you, sir. Another question is the test for mergers. Well, the effect of the merger. What are the merger tests that ERCA will undertake? Is it a substantial lessening of competition or creation of a dominant position?
No, actually, in ERCA's legislation, the dominant position, as it is the case in many jurisdictions, is not per se the problem. Having a dominant position is not actually the problem, is the abuse of this dominant position that is prohibited. So is to look at if a transaction is going to have a negative effect on competition.
Right.
And consumer protection is what matters for us, and it's what we consider when we are making our assessment.
Yes, right. SLC. Thank you, Doctor. Another question that we have here is the reference to days in regulation CREG 23/12/21 on the rules of procedure for M&A in ECOWAS, does it refer to calendar days or business days?
Okay, thank you for this question, because it's referred to business days.
Business.
It refers to business day because, well, it's clear that there is another regulation on the investigation procedure and notification that clearly mentioned that any period limit times is in business days. And this one, so it's referred to business days.
Yes. Right. Okay, so that's definitely business days. Because they also said that in this regard, we note that enabling rule PC Rex 10124 on manuals of procedures in the ERCA defines days as referring to calendar days. However, regulation on the rules of procedure in competition matters provides that Saturdays, Sundays, and public holidays are not taken into account. So there appears to be some document that does refer to calendar days. So we can rest assured that you will use business days.
None of is business days.
Yeah.
And unless is referred, is said otherwise. Otherwise,
okay, if it's specifically
business day.
Right.
Yes.
Right. Okay.
But if you make it specific to calendar days, that one has to clearly be stated. Yes.
Okay. Right. Business days until otherwise informed. Right.
Yes.
Okay. Thank you, sir. A question is, does the ERCA have any priority sectors or conduct that it wants to look at initially?
Yes. Actually, you have some sectors that, as I said, critical sectors that also consider at the community level, community institution level.
Yeah.
I have a ECOWAS Commission because we have our vision, and the vision give priorities to some certain sectors that have to be considered in our various program and projects that we are implementing. And the competition authority also look at and the provision of this vision.
Yeah.
So the agricultural sector is one of the sector that under review. You keep under review this sector. This is why we conducted a market study on this sector.
Yes.
So you have also the health and pharmaceutical sector. The pharmaceutical sector is also sector that many concerns have been raised by players and also consumers in these sectors. So it's also a sector that is also under review.
Right.
And also the digital market. We justify the study that is underway. It's a very evolving sector, and where at the national level, there is no clear regulation to monitor these sectors. Mm-hmm. So these are key sectors that we try to look at.
Yeah.
And I think it's something that you will come up with some result and also possibly some investigation very soon.
I see.
Yes.
Okay, thank you very much. Thank you to Nazira and Lizelle for helping me out with special drawing rights. That's great. Another question, are there any plans to issue guidelines on merger procedures or analysis by the authority?
Please come again.
Is there any plan to issue guidelines on merger procedures or analysis?
Yes, there is I think there is a guideline that you're going to make it public very soon.
Really?
Because there are few discrepancies that you have to look at and make it public very soon. There is a guideline. Yes, I think we'll share, it will be on our website, and everybody can. Yes.
That's lovely. Thank you very much, Doctor. How accommodative is the ERCA of civil society participation in the regulatory process?
Yes, this is important, and I think what you used to do is during the regulatory process, you start by sensitization of all the relevant stakeholders. All the relevant stakeholders to be sure that they are not only informed, but their opinion are taken into account in drafting the regulation. So there are all this work that you see started by the institutional analysis. The institutional analysis took us to all the 15 member states where you are able to meet with various stakeholders, government stakeholders, private sector organization, and civil society organization. Yes, so you have instruments, even though you may not have a regulation that cater all the aspiration of the various groups, but we try to at least be sure that all the interests of the parties, of the groups, states, private sector, and civil society are taken into account.
Yes.
Yeah.
Yes. And Doctor, will you notify the public when a merger is notified? And will there be an opportunity for people or for companies to make representations? That's the first question. And secondly, will your final decisions be published?
Yes. Once the merger is filing, the public is notified. The public is notified for them to bring also if they have some input or some concern regarding this merger. So they have to be aware. So so this the filing bring us to bring to the public the operation that's going to be taking place. So you notify to them.
Yeah.
And also, yes, the parties we are open to any representation by the parties during the process, considering the application.
Yeah.
Before the decision,
It's
the
made.
parties can make a representation.
Yes.
That one is allowed. It's allowed.
Right.
And the decision is published. There are various channels can be published. It will be published on our website, also our committee gazette.
Fantastic.
So that one is,
that's absolutely great to hear. Thank you very much, Doctor. Just a question, do the provisions in Chapter 3 of Regulation of 24 December 2021 on the ECOWAS Rules of Procedure in Competition Matters also apply to merger investigations? So, for example, we note that there are provisions for intervention by third parties in investigations. And does this also provide third parties with the ability to intervene in mergers?
Yeah.
Right.
Yeah, third party, yes. Yes, is also with a provision concern also mergers.
Yeah.
Yes, because it's the purpose of make it public.
Yeah.
Yes, to allow third party to come and raise their concern regarding this transaction.
Yeah. Right. Right. We have a question. As the ECOWAS court is a general court, are there plans to set up a competition division at the ECOWAS Court of Justice made up of specialist judges with knowledge in competition law? Or is it too soon to tell?
No, ECOWAS, no, what actually what is in the plan is not to have a competition court at the ECOWAS level.
I see.
It's but this court, the ECOWAS courts, now is playing this role, and I can confess that not all the judges that have knowledge of competition rules. That's why you are organizing some
all sorts of training,
capacity building,
yeah.
training for them. We are in the process of train the community court judges on all these regulations, and but they are in arbitration. Actually, they are also in a mandate. They have is a kind of arbitration court.
Correct.
When it comes to all the economic affairs. Yes, the trade and commercial affairs, they are also within the scope of intervention. So we have a broad idea of activity going on the regional market.
Yes.
Even though specificity of the competition law may not be familiar to them, but we are working towards to train them, and be sure that they master our regulation, yes, as appellate court.
Yes, that's great. Okay, another part of the question is some overlapping jurisdictions of WAEMO and ERCA comes to play at the court level. What are the plans for the conflicting jurisdictions of the ECOWAS and WAEMO Court of Justice?
No, the Court of Justice, there is no appeal for a decision of the Court of Justice. It's the final decision. Once the party are not okay with the decision taken by the competition authorities, they go to appeal to the Community Court of Justice, and the decision is final. The decision is final. There's no any other appeal to the decision.
Yeah. Yes. Yes. Right. There's a question. Is there any intention to place a cap on the merger filing fee?
Yes, I think this question, yes. This question, actually, the reason why it is like that is that during the assessment, the drafters of this regulation, we conducted a serious assessment because a market study to even defend all these things.
Yeah.
There were no situation where, at least they did not come up with a situation where the rate, I mean the amount that will arise from the calculation of this fees will be exorbitant or at a certain level that is not possible for the businesses to, because yes, I know there are many jurisdictions where there is a cap, 200,000 US dollar to 300,000. But there's no cap, but the regulation give a possibility of ERCA to define the modality of payment. Yeah. I mean, and within modality, you understand that you'll consider what is reasonable as fee without allowing by simple mathematics to go to a level that going to be reasonable for as a fees to payable for businesses. So business should not be worried, should not worry about the fact that there is no a cap, but in the implementation, I'm sure that you will find a way to have a kind of boundary.
Right. Thank you, Doctor. what is the basis for the operation of the ERCA in member states, in brackets, dualist states that have not domesticated the supplementary acts and the other ERCA legal frameworks?
The basic is simple. As I said in my presentation, ECOWAS jurisdiction is triggered when a member state alone cannot address the issue. You understand? When a member state alone cannot address the issue. I'm going to give you two reasons that justify the jurisdiction of ECA. When a country A decides to trade with a country B in the community market, and there is an issue of competition, who is qualified to address this issue of competition? Country A and country B cannot address this issue. It's only ECA.
That's right.
And the legal basis you are talking about is the ECOWAS Treaty. The ECOWAS Treaty in the amended protocol say that the supplementary act is applicable in all member states. And if you take all the acts, it asks all member states to take all necessary measures to comply with the provision of the act, including what we call domestication. So member states have to take action to ensure that the provision of the act are implemented in the countries. So that one is clear and the provision is there. Yes, it's something that, so what you are doing is why you have been engaging member states to take these steps. Domestication, and also put in place legislation and institution that will ensure implementation at the national level of the national competition provision and also the regional provision. But there is a clear legal framework that gives the mandate of ECA to intervene in the member state, because otherwise it's the same supplementary act, the same, and not the competition supplementary act. There are other supplementary acts that supplementary protocol that establish the trade liberalization scheme that allow companies to come and request for approval to go and trade with other member states. So you cannot decide or come and request for approval to go and trade with other member states and at the same time not comply with the regulations
other stuff
of this market that are common or aims to be common and integrated. So it's there are various provisions that justify our intervention in member state.
Right, right. Thank you, Doctor. To what extent will ECOWAS consider public interest considerations in the
Yes,
merger?
public interest consideration. Yes, our provision is not giving details.
Yeah.
Because public interest is something that can take so many dimensions. When a sector is vital for the economy, for instance, a sector that can be considered as especially we find this kind of sector in the agricultural sector that provide food and so on. This sector can be considered as a public interest. There are other sectors that are also important when it comes to health. You saw that during the COVID pandemic, where various member states have to, let's say, in the name of public interest, allow critical companies in the sector to take measures that sometimes were contrary to the competition provision. So there's no specific list, but you can clearly identify some reason depending on the situation.
Yes.
But yes, so for us, public interest will be considered and analyzed when the situation occurs.
Presents. Yes,
so
I see.
it's why there is no specific that we can
provided.
give. Yes.
Yes. Will that also be part of the guidelines? Something on the public interest?
No, there's no for now a clear guideline, but we can. Yes, I think.
Maybe if the merger guidelines can just contain a paragraph.
Yes.
Yeah.
Exactly. Why? Oh, yes. I think it's also a purpose of this exercise to also, and that you are also learning from others.
Yeah.
I think there are various areas where you can also improve on, and a guideline will not be out of context.
Yes.
That is well noted. Thank you.
Right. Thank you, Doctor. We noted that there are a period of 135 days, all in all, within which to review the merger. And the question is, can we reasonably assume that if there are no competition issues, that a merger decision will be issued quicker?
Okay, so you came up with 130 days.
135.
135, 135. No, it can be far less than that one. Actually, as I said, it's depend of the availability of information.
Yes.
It's why you ask businesses to provide the information required.
Yeah.
Some may find that the form is lengthy, but actually it's not. Because once you have this information, it will fast track, make go faster in the evaluation, and also come up with a decision as quickly as possible.
Yes.
This number of days are the maximum in some extent, but what you have to look at is the 60 days. I think within 60 days, you may not require extension, because if you have the necessary information at the first submission, at the first submission. Is why it's important you insist on that. At the first submission,
Yeah.
let have the necessary information for us to go easily with a review.
Yeah. Right, right. Then, Doctor, just a question regarding how often will the council members sit to make a decision? So even if you have reviewed a merger, let's say in 30 days, may it happen that a merger must wait 60 days because the council only sits every 2 months, for example?
No, actually, yes, every 3 months. What is said every 3 months,
Yeah.
but they can be called for if a need arises. If a need arises, they can be called to sit. So, still statutory 4 statutory days meetings, but it can be more than that.
Okay.
You don't need to wait till the next session of the council to consider cases if
Yeah.
it's important to call them before the next session.
Okay.
And there's also, it may not be always physical.
Wonderful.
You can use the
Zoom.
yes, exactly.
Exactly.
Electronic,
Yes,
exactly.
that's right.
To review. You don't need to bring them to Banjul or anywhere for a
Yes.
physical meeting. Yes.
Yeah, that's great. Another question from this side is, are full function and non-full function JVs treated the same in respect of merger notifiability? I.e., to the extent that a non-full function JV satisfy the requirements for notification, in that it operates in at least 2 ECOWAS member states and satisfies the thresholds, will the creation of this non-full function JV, including those with a limited duration, be notifiable?
Yeah, I can see that there are so many questions around the notification. Like business, I want to skip this step, but well, can you come again with your question?
Yeah, the question is basically, is a non-full function joint venture also notifiable? And that is on the assumption that it meets all the thresholds, but it is actually not full function, so it is of limited time period, only for 3 months, then the parties will go their separate ways again, never speak to each other. So would that be notifiable?
Okay, only for a short period.
Yeah.
No, but I think when it comes to effect of a transaction in the economy, even a 1 day action can have an important effect on the economy, on the market. Because of this kind of transaction, you have to look at. And also, I cannot say that it should not be notifiable. It has to be notified. It has to be notified. But because we cannot predict the consequences of this operation until you have a clear picture through a review. Through a review.
I see.
So, yeah, yes. For me, I think and that's what, so there's no, when you take the regulation, differences between in terms of time frame. So,
And Doctor, maybe that could also be something to be discussed as part of your pre-merger consultation meetings. If there's a clear kind of anomaly, I guess that is also something that one can discuss with you prior to filing. Then just quickly, somebody asked, how will ERCA handle a merger between an ERCA member state and a non-ECOWAS member state? But I guess that would then not be notifiable at the ERCA. It will be notifiable at the two different national jurisdictions, I presume, because your regional dimension test is not met.
no, you cannot say that rapidly.
Okay.
Because there is a non-ECOWAS country and ECOWAS country, an ECOWAS country.
Yeah.
And we are going to a merger.
Mm.
What are the activities of this ECOWAS entity? This ECOWAS entity.
Mm.
Are they involved in cross-border trade or not?
Mm.
If they are not involved in cross-border trade, especially if they are in a particular country and the operation is only in this country, it doesn't concern ECA. But if this particular entity action goes beyond the country, as I said, the operate is not only physical, it's not only the physical presence. I'm saying that many companies are coming to supply, to sell to other countries, to also purchase goods and services from other countries. So you have to consider all this.
That's right, yes.
It's why you cannot easily conclude without having entire picture.
That's right. One would basically keep in mind what is the definition of operate and keep that in mind as well. Right.
Yes.
Right. If a company does not file with the ERCA and the ERCA calls for the transaction, what would it look like in a world where the gap between the signing and the completion of an agreement is short, or the signing of an agreement and the completion of the transaction is short? So I think this also speaks to the whole issue of how quickly must a merger be filed? And is there a particular time frame within which that must happen?
No, there's no in the regulation a time frame to come and file a merger. But the rule is clear until the merger is approved, the transaction cannot be effective. Yes. So, yes, you cannot just say that you have to come and file a merger. No. Come and file a merger.
Yes, but when? But when exactly, Doctor? We are mindful that I think at COMESA you have to file the merger within a certain couple of days after you signed the agreement. Is there also that type of a provision?
Which agreement?
The merger agreement or your transaction agreements.
Well, it's what I'm saying. you have to file the merger
Before.
prior, yeah, before.
But
Before.
yes, but sometimes there are still
And
condition precedents, so you can sign a merger without it becoming effective. And I think this is what COMESA tried to capture, is to have that notification.
Our regulation, you have to file the merger, have a decision before you
Implement.
you go into you implement it. Yes.
Yeah.
You cannot implement and come and file later.
Yeah.
Yeah.
That's right.
No. You have to get the decision before implementation.
Yes, that's right. And that is part of the whole suspensory aspect. But
exactly.
But is there a time limit within which you must file it? Let's say within a certain number of days.
The time limit within which you must file.
Any time before implementation.
No, actually, it's maybe I'm not getting your point, but two entities want to come into want to merge. Let's get it clear. And you are asking if there's a time for them to come and file this merger. What I'm saying, there is no time for us. There is no transaction until there is a decision. Yes, there is no, for us, there is no, nothing has happened. So up to them to decide when they are ready to come to the Competition Authority to file.
Right.
And then this operation they want to go in.
Right. Okay.
Do you get my point?
I do, as long as they don't implement.
Yes.
Yes. Okay. That helps a lot. That helps a lot. Thank you very much, Doctor. Let's quickly see the remaining questions appear to pertain to domestication, and I think we've discussed that. Let's rather just focus on the practical ones for now. Yes, just another question. Given that some ECOWAS countries are also members of WAEMU, what would happen if IRCA refuse a merger and then the companies take the matter to the WAEMU Competition Commission? Is this something that would be covered by your MOU so that this doesn't happen?
Yeah, it's fully covered by our
yes.
MOU.
Yeah.
If I receive a notification, immediately I inform my colleague from UMOA.
Yes, I'm sure.
Immediately,
I'm sure.
You even planning to have a digital integrated platform that will be on a daily basis exchange of information, so on. So it cannot be done in our agreement while a decision is taken here.
Yeah.
I'm not happy if I go to the other authorities.
Yeah.
No, that is not feasible.
Yes, right. Will the IRCA issue advisory opinions? For example, to say, let's say we don't know whether a merger is notifiable, and can we come to the IRCA and ask an advisory opinion, and you analyze it, and then you say, yes, the merger is notifiable, or no, it is not. Is that a service that you render?
No, there's no problem with that. There is no problem to discuss with parties before they start the operation. You can discuss. Yes, they can seek for clarification and can provide whatever advice you think you can provide to them.
Yes.
Our role is to facilitate trade, not to to be against any business is to be sure that
Yes.
things are done properly. So
Yes.
we are ready to assist even
Right.
before filing. Yes.
Okay. And will that be in writing? In other words, will you provide a formal response? I know in the previous years in South Africa, there was that service where you pay a certain amount and then you get the formal opinion and you put it on file and you know that you are safe.
No, for after you to be informal because you are not going to you are not going to provide a formal right, put it in writing and so on.
I see. I see.
It's a formal discussion
Formal
before,
discussion. Oh,
yeah,
yes.
before the things done properly by
Yes.
five. Yes.
Okay, right. And just a quick question, will internal restructurings be notifiable? So let's say one subsidiary or a holding company, one subsidiary moves internally to eventually sit under another wholly owned subsidiary. So there's no effective change of control. It's still the same economic entity. Is that something?
Yes, you know, so in that case, yes, if it's internal restructuring and that doesn't have any
effect.
Yeah. Yes, no, there's no need for notification. Yes, because it doesn't be. I don't think it's considered as a merger or acquisition per se. Yeah.
Yes. Right. I think we are nearly there. Let me just quickly ask something else, Doctor. In the beginning, you mentioned that the Consultative Competition Committee may at some instances provide an input in relation to decisions. And where and how do you see that happening? For example, if the executive director finalized its decision and it is sent to the council of, let's say to the board, will the board finalize its decision? And then will the CCC be requested for input? Excuse me.
No, this happened after the report of the draft decision of the executive director.
I see.
After that,
right,
you may call the CCC for share for them and for seek their opinion.
Yes.
And also not only CCC members.
Yeah.
Also experts in the field.
I see.
Because they have to, yes. So that one is something. Is after that the draft decision is taken to the council, ECA council.
I see.
And the decision, the opinion is I think is something that is clear. The opinion is not, it may be favorable or not. In that case, it cannot affect or change or reverse the decision of the executive director.
Yeah. That's very interesting. Okay. And Dr. Simeon, is it also possible for you to call for a merger that does not meet the thresholds?
You know, when it comes to the problem with having thresholds is always the question of the boundaries. Because you said 20 million.
Yeah.
If you have 19.9 or 19.5, what do you do? But it's true that we may be under our threshold. You can consider these mergers if relevant member state, or our partners from, for instance, from UMOA, which threshold may be lower than our own, ask us to consider this measure.
That's interesting. I see.
Upon request by either a member state of our partner, because they enter into their jurisdiction and they may seek our support to review this measure. So in that condition, yes, but otherwise, you consider those who are within our threshold.
I see. Right. That's very interesting. Okay. Have you received any merger notifications in the last month?
Last month, not yet.
Not yet. Okay. Right. Ladies and gentlemen, if you don't mind, there are a couple of questions regarding domestication. We're not going to go there because that has been addressed. And it's also 2 hours later, and we still have 38 participants. I'm very proud of the tenacity of our audience. It just shows you how important this discussion is, Dr. Simeon. We really appreciate you spending so much time with us today. Thank you so much for your patience with us and for explaining not only the answers, but your thought process and all the things that's happening behind the scenes. And there you can see there are lots of claps for you. That's just for you. Thank you so much for helping us today, Doctor. I think we must keep you on a short leash. Maybe again call you in next year at some point, but I think you helped us so much already, and thank you very much for that. So we really appreciate that. It's been extremely helpful.
Thank you, Odi, for inviting us to this webinar. I think it's very interesting, and it was an opportunity for us to present our media regime, control regime. I think we may not be able to exhaust all the questions. There are so many pertinent questions. I think some are still in the chat, and but I hope you have other opportunities.
Yes, we will.
To interact and also share. But they are sure the businesses and the representatives, the law firms, they are free to send email to us.
Right.
To request for, you have been doing that. So if there is they want to seek more clarification in a very special aspect of our rules,
yes,
provision, they are free to do so.
Thank you so much.
We are there to assist and also assist that and be sure that everything is done smoothly for the benefit of our all the players of the market.
That's right. Yes, thank you. Yeah, thank you for that, Doctor. And also, Dr. Juliette, thank you for being here today and for taking part in our Q&A. We really appreciate that. And I can also confirm that the address, I think it's info at rk-arcc. That works well. I understand that there's a quick response, well, at least within a day. So it's really, the RK is really doing its bit to make sure that questions are answered on a fast basis. And that's really also very helpful. Thank you very much, Doctor and Doctor. It's been lovely, and I hope that you have a very restful weekend after this exhausting Friday afternoon.
Thank you. Thank you very much.
Thank you very much. Thank you. Thank you. Thanks, ladies and gentlemen. All our participants, have a lovely weekend. Bye-bye.
Bye-bye.